Hi everyone, I am Shweta Kumar Devgan. I am a content consultant at Lawsikho and also the operations manager for its upcoming judiciary course. Now, I know that it feels like we are going through very tough and uncertain times because one, we are being made to stay at home. Two, there is social isolation. We are not able to meet anyone, speak to anyone per se. Three, the organizations are shutting down temporarily and so on and so forth. But if you are an individual who is planning to prepare for the judiciary exams or has been preparing for the judiciary exams since quite some time, now is the time to sit, deliberate, and start your preparation. So this is an opportunity which has been given to you, and this is the right time to not skip this opportunity and make the best use of it. Now, what needs to be done with this regard? Find yourself a quiet corner and begin. Why I am saying so? One, because right now there is possibly zero externality with respect to your preparation. You have all the time to focus upon. Then there is no college, there is no court, there are no submissions, the exams have been extended. So you have all the time to sit and prepare. And of course, these 20 days are going to give you a push to set in your preparation and follow a particular routine. You have very rightly heard Narendra Modi's speech where he says that it takes around 21 days for you to start to get into a habit, and right now is the time to do so far as your judiciary preparation is concerned. So as I am speaking about this, literally right now is the time to sit down and begin. Now, before starting, as judiciary aspirants, we often feel daunted by a lot of questions, such as one would be that there is vast syllabus, which is extremely intimidating. Then is that you haven't probably been in touch with studies for a very long time. Maybe you are a practicing advocate here and you feel that it's extremely difficult to open your books again. And probably you're only half decent at substantive laws and you feel that procedural laws are extremely daunting and maybe it is not the right time to start. You have a lot of similar such doubts. Or probably you are only a first-year student or a second-year student and becoming a judge is your dream, but you have no particular roadmap that you feel needs to be followed. Or maybe you are a professional or you're a housewife and you're feeling that when is the right time to start or when is the right time to feel that you're prepared for the exam. And which state judiciary you should particularly appear for. We know that as of now, the judiciary exam is a state services. We are familiar that every state conducts its exam either yearly or twice a year, including some union territories such as Delhi. So here the question arises that which particular state's judiciary should you prepare for? Now, another question that comes in every individual's mind is that is joining a renowned coaching institute a one-stop solution to everything? Can self-preparation work? Do I need a mentor or a person who has cleared the judiciary exam and only he or she can guide me? Should I prepare for the preliminary exam first, then the mains, and then the interview? So there are a lot of questions that come across each and every individual's mind when he's preparing, when he's sitting down with his books or she's sitting down with his books, her books. There are a lot of questions that constantly keep coming to your mind, like, will I be able to clear this exam? My parents are not lawyers or they are not judges. Will I be able to crack? Or maybe my parents are lawyers and judges, so I have all the resources on this planet to crack the exam. You either feel way too optimistic or you feel way too discouraged about the entire situation, or you feel that you have a lot of time to prepare and hence it can be probably be kept for the end. Maybe you feel that all you need to sit for the exam and appear for the same is just 6 months and you will be good to go. But maybe that is not the situation because it varies from individual to individual. Or you feel that whether you should have a backup or not. And lastly, that maybe there are times when an individual's parents are pressurizing that person, or there's a lot of peer pressure, there are a lot of people who are preparing for the exam, and there's questions that constantly come to your mind, right? I would just request everyone to please mute themselves and also to please shut down your videos. That will be really great. Yeah, thank you. Coming back, now These are the questions that literally boggle almost every judiciary aspirant. Now, before we begin to find solutions to these particular questions, like I have just got a particular question here which says that what is the best method to interlink subjects and study? Please guide with respect to this too. Yes, of course, we're going to take up this questions as we go through the series of this particular session. But before taking this particular question, let's burst a few myths that are following this particular exam, specifically the judiciary exam, but is also interrelated to a lot of law exams. Your first myth is that competitive exams are only about your previously tested intelligence. I have never scored well before. Will I be able to clear this particular exam as well? Now, this is a completely false notion to even adhere to. And this is appearing as a mental block if you have such a doubt in your mind that you have not been a very good student before, and probably preparing for this exam is going to, probably your preparation is going to be hampered by your previous scores. Now, any competitive exam, let it be UPSC, let it be a law entrance, let it be the judiciary or the legal exams, are more about your basic knowledge. And how consistent you are with respect to your preparation makes a lot of difference. They actually have very little linkage to your previous scores, that is only at the qualificatory level. So there, if you read through the notifications of various state judiciaries, you will find that there is a level of qualification that is required for you to sit and appear for the exam. One is with respect to the age, second is with respect to your marks in your LLB, which most likely rounds around 50%. So if you're a student who is scoring between 50 to 55%, you're eligible to take this particular exam. Now, second myth is that only students who are studying for 10 to 12 hours a day can crack the exam, or only hard work or only sitting, only a long sitting is going to ensure that you're going to clear the exam. The answer to this question is a very blatant no. While hard work forms a very important component, smart work is what helps you achieve your goal. Consistently studying for 4 to 5 hours a day with concentration and focus is going to make a lot of difference. Towards the end of this particular lecture series, I'm going to tell you how dividing your time can help make the right strategy. The third myth is that I need to read a lot of books and a lot of content to clear this exam. Now, this is something which a lot of us fall into. Often when we begin with our preparation, the first thing that we do is go to a market, or now we can't go to a market. So we'll open one of these online websites from where we can order these books. So the first and foremost thing that we do is that we sort of look forward to create a repository. So we'll see what all material is available on the internet. A lot of us would probably go to the DU website and download their entire free material. A lot of us will go to the NLS website, download their free material. A lot of us will refer to a lot of blogs. There is LawWeb, there is iPleaders. There is so much information that is available online and otherwise for hard copy and soft copy books. So as an aspirant, as a candidate who wants to sit with certain material, our first focus generally, which is not the right thing to do. Now, do we need to read a lot of books and a lot of commentaries to be able to clear this exam? Well, if your goal is to get into research in future at any point of time, it makes a lot of sense for you to do that. But if your goal is to become a judge in future, is to appear for the lower judiciary exams, then it is not the right strategy to follow. We'll also discuss what is the ideal way to go about the certain books. And if you have to shortlist some books or commentaries, what should these books and commentaries ideally be? Now, the next myth is that reading the interviews, and this is the most fascinating and the most interesting one because all of us fall for this. When we sort of picture ourselves as future judges, the first thing that we do is look upon the internet for interviews of all those people who have cleared and see if we can follow their pattern. While it's a very good thing to remain inspired, reading the interviews of people who have cleared the exam or socializing with those who are preparing will help you clear as well is still a myth. It is not a reality. What is required for you to prepare for this exam is to, one, come up with a good strategy. Second, only take guidance of others till the time it helps you, and learn to draw a line. So definitely a lot of people who have cleared the exam would tell you that they used to study for a certain period of time. They used to read from the following books or materials. They joined a particular coaching institute, and that's what helped them. But what makes most of the difference is how you are, what is your way of line with respect to this particular exam. Now, someone has asked me a question on how to deal newspapers for the judiciary exam. There's a way to read the newspapers when it comes to the competitive exams. Ideally, 1 hour is the time that you should devote towards reading newspaper. There's a strategy for the same, and I'll definitely be sharing it with you all in one of our webinars. So for now, just make sure that if you've started reading the newspaper, you're sticking to reading the newspaper for not more than 1 hour, and not depend on any other source apart from the newspaper so far as your general knowledge preparation is concerned. Moving forward with the 5th myth. Just doing the past year papers is sufficient. Now, if you meet anyone who has cleared the judiciary exam, they will tell you that I just did the past year papers and that was more than sufficient because a lot of questions were repeated. Now, while this formed a very good strategy for a very long period of time, is it something which still appears, still applies to the judiciary exams when it has become so dynamic in nature? Well, the answer to this is that dependence upon past year papers is a very good strategy to begin. But thinking that it is your end-all solution, you have covered the past year papers and you're good to go, is not a very right idea to sustain with or to continue your preparation with. Why I am saying this is because if you take a look at the past year papers of maybe the Delhi Judicial Services or the Punjab, Haryana, and even Himachal in the recent times, you will realize that a lot of questions are persistently changing. For instance, the Himachal judiciary is deliberately changing upon its pattern and focusing more and more upon case laws and local laws because they want to make a change from what pattern they have followed in the past. Also, particularly with the All India Judicial Services coming into line, coming into charts, it makes a lot more sense to, yes, rely upon the past year papers up to a certain extent, but not make it your end-all solution. I've received a question here. Ma'am, will you be speaking about different state judiciary exams and there are different laws for each state? In this particular session, I won't be, but in future, in this particular session is a uniform session. But in future, yes, we will be taking individual judicial services webinars as well, right? Okay. Now, the next myth that we often come across is that let me study the law first and language and general knowledge will take care of itself. I'm happy that an aspirant here has raised a question for judiciary because it is very important to understand that while emphasis on law is no doubt very important, here several candidates are not able to clear the exam only because they lack general knowledge skills or language skills. So if you are looking for a state judiciary exam where general knowledge or language is a component which is equally tested with law, you would not be allowed. It is not an ideal way to go that you are only focusing upon the clearly sort of ignoring the other areas. Okay. Now, we also see that there are a lot of states where the weightage is given only to where a lot of weightage is given to language and general knowledge. So in that scenario also, it is important that you take all these three aspects together. You take your general knowledge, you take your law, and you take your language skills together. A lot of us feel that we are probably really good with our regional languages or maybe English or Hindi. Yes, that's true. But let's say you are tested upon Hindi and you are asked about technical terms like what is an engineer called in Hindi, or maybe what is internet called in Hindi, or who is a psychologist, what is he called in Hindi? Can you answer these questions? Or what is a judge called in Hindi? What is a judiciary premises or a complex called in Hindi? There's so many technical terms that you would constantly be questioned upon. So unless you're very confident with your language skills, it is not ideal to ignore them in the process of your preparation. Now, someone has asked a question here. Ma'am, can you please advise the ones in law schools how to start preparing while studying the course? Yes, I'll definitely be addressing this during the course of this particular lesson. Now, the next myth that we always often come across is that I already know a lot, I'm going to do great. Now, this is the best for those who are studying in law schools, because we are generally overconfident beings when we are studying in college, and it feels like, yes, it's just a step away, and then the moment we are going to pass out, we're going to become a judge. While it is a very, very good attitude to keep, one must remember that just like overspeeding kills, even overconfidence kills. So there are people in the best of the national law schools who have not been able to clear this exam, and there are people who have who have been preparing through the course of generally while they've been studying in other law schools and generally from tier 2 colleges maybe, but have cleared this exam with flying colors. So it's very good to have a very positive attitude towards this exam, but please do not feel overconfident. It's very important to not ignore this aspect, because as much as your knowledge matters, your frame of mind also equally matters. Now, the next question is, let me sit for the exam. It's okay if I fail this time. I will definitely make it the next time. Now, this is also one of the myths that we keep, and this is particularly important for people who are studying in law schools. A lot of times when we are in the 4th year or the 5th year, we feel that now it's the time to sit for the exam and to start preparing. And a lot of times it so happens that when you are in your 4th year or your 5th year, you are also about to pass out from college. So there are a lot of other things there are a lot of extracurricular activities that you want to make sure that you're focusing upon. While you're doing all of this together, while you're in a 3rd year law college, you're in a 5-year law college, you are working as an advocate, you are a housewife, you're doing other stuff while you're preparing for the exam. One thing that all of us have to remember is that your first attempt is always your best attempt. So even if you don't make it in your first attempt, despite it being your best attempt, how it will help you is that you will be inclined towards identifying your mistakes and making sure that they are rectified in future, in your next attempt. But if you don't do so, if your first attempt is not your best attempt, what will happen is that a cycle of failure will start, and your mind will start accepting it. Your mind will feel that, okay, if it has not happened this time, you'll put a reason to it. You will say that it's fine, I was not prepared, or I had prepared only one law, or my general knowledge was not good. It's okay, I'll study all these things in the next attempt. You have to remember that a casual attitude towards any competitive exam is absolutely not helpful. So please only sit for the judiciary exam when you are in the right frame of mind, when you feel that it's time, you're ready to take this exam. And again, you are giving your attempt with the sincerest efforts. Another myth that we often come across is, I will simultaneously fill a number of forms of different state judiciaries, and I will definitely crack one of them. Again, this makes a lot of sense when you know that you're well prepared and are well aware of the basic concepts inside out. It is not advisable if you are a novice. So if you are starting today, which is the purpose of this particular webinar, that you are starting with your preparation for judiciary, your ideal aim should be to shortlist a particular state's judiciary that you wish to appear for and be very familiar with its syllabus, right? Okay, so I'll just take up a question here. Someone has said that while reading newspaper, there is always a problem for me that which topic I should focus upon. I would request you that I will be taking a webinar on how to read the newspaper for a competitive exam. So let's make it a different subject altogether. If anyone has any questions with respect to the topic that we are currently focusing upon, please ask your questions accordingly. Okay. Now, the next question that we often, or the next myth that we often come across is that I'm only born to become a judge. No other profession is suitable for me, right? Now, while it is a great idea to approach this exam with a lot of focus, but not having backups or putting all your eggs in one basket is not a very practical approach, as it not only puts you in a very vulnerable spot with respect to your career, but also restricts you from a lot of practical avenues that are otherwise open to a lawyer. Having said that, so while you're preparing for the judiciary exam, you would focus a lot upon theory. Your focus would be to understand the theory of procedural laws. Okay, so coming back, now a lot of people come up with the idea that not having a backup plan is okay, and you're going to possibly pass your phase through the preparation. One thing that you have to remember is that while you're preparing for the judiciary exam, a lot of your focus is only upon theory. So even when you are learning and understanding the procedural laws, you might be reading an Order 7 and Order 6, which is telling you about pleadings, plaints, Order 8, written statement. You're being told about all these things. But if you haven't understood these things in the practical aspect, if you don't know what a plaint looks like, if you don't know how to file a plaint, it's not a very advisable approach to move on with your idea. Why? Because one, in the long run, it'll start to make you feel very, very underconfident with your preparation. Two, your peers might be practicing advocates who are preparing for the exam simultaneously. You might feel that probably you are doing a bit less than them. And three, it is again, as I've already mentioned, not a very good option to keep all your eggs in one basket. So you should always have a backup plan, even though your focus is entirely on clearing the judiciary exam. What can be your backup plans? One, to always join as a practicing advocate. So a lot of us make the mistake that while we are preparing for the judiciary exam and we have passed out from law colleges, we forget to enroll, or we take our time to enroll, feeling that it's not important for us because enrolling is not a criteria. Enrolling as an advocate is not a criteria to appear for the judiciary exam. However, when you are sitting for your interview, a lot of times the questions are based on practical aspects of law. So again, while not just thinking about keeping a backup, but otherwise also, as soon as you pass out of law college, it makes a lot of sense to enroll yourself as an advocate. The second option that you can keep in mind is about is keeping teaching as an option. Because you would have such a good mastery over the theory, it makes a lot of sense to pursue an LLM or a higher degree side by side while you're preparing for the exam, so that just in case, unfortunately, if it so happens that because of some reason you are not able to make it, or it is taking you more than one attempt to clear the exam, at least your confidence does not break and you are doing something or the other. So before moving, let me take another question here. Someone is saying that whether AK Jain for judiciary, the dukkis as we rightly know them, are they sufficient? It depends on how you're using these dukkis. So if you are referring to these dukkis or AK Jain books without connecting the dots with other subjects, without referring to your Bairacts properly, then it is not, then dukkis are not the end all solution. Then dukkis are not something which is going to help you crack your exam. But if you are using dukkis only as a reference with other materials such as your past year papers, your landmark case laws, and your dukkis have been updated, which they have not been for a very long time, I would suggest that dukkis is actually maybe 10 years back, it was a very good idea to study from dukkis and clear the exam, but right now it is not. someone has asked the question, I'll just take up the question side by side. Someone has asked a question. It is often said that it may become difficult to manage work as an associate and preparation for judiciary. Now, what is the ideal strategy here? I have already mentioned before that it does not take you 10 to 12 hours a day to prepare for the exam. What matters is finding the right strategy and doing some smart work. In all of this, there are three key components that you have to focus upon, which I would be touching upon through this course of webinar as well. First is to learn to divide and learn. Second is to revise. And of course, third is that consistency is your key. So if you're consistent with your preparation, if you're putting in 4 to 5 hours of your, if you're able to take out 4 to 5 hours for preparation daily, you're good to go. You don't have to depend on anything specifically. Then there's another question. Is it true that Indian judicial services will replace state judiciary exams? Yes, it is very true. All India Judicial Services is just online. It can be introduced at any point of time. Yes, there are two questions with respect to it. As of now, the syllabus is not clear, but you have to be very sure that your substantive laws and your procedure, CPC, CRPC, Indian Evidence Act, contracts and specific relief would definitely be questioned. Okay. Now, we have seen a lot of myths. We have discussed a lot of myths with respect to this particular exam. Now let's see what are the key mantras of starting your preparation. First and foremost is to have the right environment. So please find yourself a quiet, peaceful corner where you can sit and concentrate. That is the most important thing to begin with. If there are some people who find it conducive to sit in a library and study for long hours, that is a very good option, but we don't have that option right now, at least not for the next 21 days. So please make sure that within your house itself, you have a corner for yourself where you can sit and concentrate. Second is to shortlist and prioritize a particular state's judiciary that you would like to focus and crack, right? So as I have already mentioned that some of us go with the idea that whatever the next state judiciary is going to come, we are just going to see its syllabus, take a look at its past year papers, and maybe sit for the exam. And prelims appears to be very simple. So most likely we are going to clear the prelims. Now that is not a very good idea to begin with. I have already told you why. Because your first attempt should always be your best attempt. Having said that, please shortlist and prioritize upon a particular state's judiciary that you would like to focus upon and crack. Download its syllabus and details from the State Public Service Commission website, whichever you intend to. Let's say you intend to sit for the Punjab judiciary or the Himachal judiciary or the Delhi judiciary. You would find all these past notifications either on their High Court websites or on their Public Service Commission websites. If not, then you would also find a lot of the details of these judiciaries even on the 𝗍𝗿𝗱𝗄𝗧 blog. So I would suggest that please open one of these notifications or one of these websites where you will find the details of the particular state for which you would like to sit and appear for. Please make sure that you have all the syllabus written at one place and go thoroughly through this particular syllabus so that you know that at least for this particular judiciary, this is the material that you definitely have to adhere to and you have to learn and understand. The next thing that you have to do is that go through the available past year papers. For each judiciary, there are a lot of past year papers that are available online. You would find these past year papers on a lot of High Court websites. You would find these past year papers on either the websites and otherwise as well. So the next thing that you have to do is that you have to download all the available past year papers. And even if you're not well versed with the laws, it makes a lot of sense to just go through these past year papers to get an idea of which of these questions are frequently repeated and which of these are not, right? Once you're comfortable with the past year papers, now your next and the most important step is to make the bare act your best friend. A couple of people have asked questions with respect to this. So this is what we are going to focus upon now, that you have to literally know the 𝗱𝗏 Act inside out. First and foremost thing that you have to focus upon is be comfortable with the 𝗱𝗏 Act. If you're comfortable with the 𝗱𝗏 Act, it makes your journey of sitting and appearing for this exam a lot more easier in comparison to the other candidates. Now, a lot of times people feel that 𝗱𝗏 Act is only important for prelims and it does not have much of role to play in the mains examination or in the interview section. Again, friends, this is one of the myths that we need to crack. Unless you clear the prelims, you won't be able to reach the next step. So please be very, very familiar with your 𝗱𝗏 Act. Coming to how can the sections of the 𝗱𝗏 Act be memorized? I'll just come to it. But before that, let's take the other aspect of the 𝗱𝗏 Act as well. As this exam is becoming more and more dynamic, it makes a lot more sense to know your 𝗱𝗏 Act inside out. It makes a lot more sense to connect the dots of the 𝗱𝗏 Act and the various 𝗱𝗏 Acts, as it helps you to sort of know a lot of things inside out as well. So, and if you've already, coming back to your 𝗱𝗏 Acts, they are extremely important. They're literally your best friends. So the next step that you do after your past year papers is that you download your 𝗱𝗏 Acts, or at least have the hard copies of all your 𝗱𝗏 Acts. Now, if you have already cleared the exam, or if you've already cleared your law, sorry, not your exam, of course, I meant your law school. If you're already done with your law school and you are thorough with all the subjects that have, if you have at least covered all the subjects at least once, it makes a lot more sense to pick subjects one at a time, to make a combination of substantive laws with procedural laws. So how, let's say you are a practicing advocate or you've just passed out of law school, what should your strategy be with respect to the 𝗱𝗏 Acts and the syllabus of law is that please pick up one procedural law and two substantive laws at one time. It is advisable to start with the Civil Procedure Code because relatively it is one of the bulkiest laws that you're supposed to deal with. Start with Civil Procedure Code and combine it with Contracts and Specific Relief Act. It makes a lot more sense to study these three acts together because again, it will help you connect the dots. So someone has asked a question here, ma'am, is there any trick to study the 𝗱𝗏 Act? Friends, this is the trick. There are two tricks to studying a 𝗱𝗏 Act. One, whichever 𝗱𝗏 Act you sit with, start with 10 sections a day, or let's say if you're starting with the Constitution of India, start with 10 articles a day. Maybe start with even more basics. So start with just understanding the table of contents, see how many sections are there. Go behind a brief history of the act. How did this, who drafted this act? How did, what was the background of this act and under what circumstances this act came into existence? For instance, if we start with something like the Constitution of India, it has such a diverse history behind it that it becomes it in itself becomes a very exciting lesson to learn just to begin with the Constitution of India. There's so many things that you would learn and understand in the process of just starting with the Constitution of India. Something like when the Constitution was enacted was in 1950, but even before that, there were certain provisions of the Constitution which were very much up and running. What were those provisions? Or when the Constitution started, there were a certain number of articles in the Act, but what is the position right now? And if the amendments have taken place, how many of those amendments have come up, right? So these are the small things that you literally have to know inside out with respect to a particular 𝗱𝗏 Act that you sit with. So if you start with, let's say, the Civil Procedure Code, please understand that your first session or your first lesson literally should be to understand a brief history about the Civil Procedure Code. Having said that, when you pass through or when you go forward, let's say even with the Civil Procedure Code, once you reach the definition section, then is when your mind should start working on connecting the dots. So let's say the definition section would tell you a lot about the other sections of the 𝗱𝗏 Act. So start looking at those sections, start connecting the dots, see which section is having similar provision with respect to any other section in the 𝗱𝗏 Act. Or let's say even if we are talking about the Civil Procedure Code, then which section should read with which order. So just creating this roadmap in your first sitting with respect to any law, let it be the Civil Procedure Code, let it be the Contracts Act, let it be Constitution of India, or let it be any other law, would be extremely helpful. Right. So I was talking about the ideal combinations that you could pick up while understanding and starting your preparation for the judiciary exam. As I've already mentioned, it is a good idea to start with Civil Procedure Code, Contracts, and Specific Relief Act. So you have three different acts, which are, one is very bulky, the other one is slightly medium, and the third one is way too short and you would be able to cover this act very fast. So there will be one act which will take you a good amount of time, which will take you minimum of 3 months to complete, finish, and be done with and be thorough with. But simultaneously, you would be making progress on the other act. So mentally, you would feel comfortable with the fact that there is a good amount of portion that you are covering side by side, and your syllabus is indeed being covered, right? Once you are at the rear end of the Civil Procedure Code, then the ideal combination that comes into existence is Civil Procedure Code with Evidence Act and the family laws, that is the Hindu laws and the Muslim laws. So this is how you're supposed to create combinations of different acts. If you start with the Civil Procedure Code and the Criminal Procedure Code and the Constitution of India together, it's going to be a disaster for your preparation, because all three of these acts are so bulky, or let's say even jurisprudence for that matter. It is literally disastrous for your preparation, because you're likely to burn out very soon. And all the procedural laws at one point of time can be very boring. So you have to make sure that you are placing an ideal combination of a procedural law with a substantive law, with a very small procedural or substantive law, so that you're constantly progressing with your preparation and the same as well, right? Okay, now someone had asked me a question on, if you're already studying in law school, then how you should go about with respect to your preparation. Now, this is a very pertinent question, because some of us are studying in first year, some of us are in second, third year, and some of us are at the rear end of our law school life, the fourth or the fifth year. If you are in your first year, please again start with what I have already mentioned. Focus upon the state judiciary that you want to prioritize, you want to start with. See its syllabus. See the subjects that are sort of repeating, which is there in your state judiciary syllabus as well, and in your course curriculum as well. It is a very ideal strategy to create your notes and learn and understand those subjects side by side. Why is this a very important strategy? One, it will not let you burn out through the course of your preparation, and two, it will sort of streamline your law school prep as well. Please do this. So let's say you are in your first year, second trimester, and by now you have studied the law of torts, and law of contracts is in its beginning, right? So it makes a lot of sense to have your past year papers for the law of torts and the law of contracts in place, judiciary you are preparing for, and simultaneously start creating a set of notes from the commentaries that are being referred to you in your law school itself. So for instance, 𝗷𝗂𝗱𝗃 for torts or 𝗷𝗂𝗱𝗃 for torts is one of those books, or similarly 𝗷𝗂𝗱𝗃 for contracts or 𝗬𝗃𝗱 for contracts is one of those books which are regularly referred to by lecturers for your exams as well. So it makes a lot of sense that, okay, you're reading these commentaries side by side to have a general idea of this. And this is because it should not happen that when you reach towards the rear end of your law school and you reach towards the starting of your preparation, you feel the need of reading these books. It makes a lot of sense to do this reading right now, keep it aside, and then again start becoming very comfortable with your bare acts. So if contracts is in your course curriculum, please start dividing and learning the law of contracts. Take the first 10 sections at one point of time. There is a way to learn and understand the bare act as well, but starting with the idea that you are every day at least covering 10 sections. When you're covering like at least 10 sections, there are two ways to understand the sections of the bare act itself. Now, if you are a person who's well versed with the English language, the best strategy to understand any section of any bare act is to divide it, right? So let's say section 378 of the code talks about theft. So it says whoever takes dishonestly any immovable property out of the possession of any person without that person's consent is said to have committed theft. Now, if I read this section just generally, it's probably not very understandable, because what do you mean by whoever takes immovable property? Like it does not strike your mind, or it does not make you understand the section very well. But if I read this section as, if I divide this section into parts and read it as whoever takes dishonestly any immovable property out of the possession of any person without that person's consent is said to have committed theft, right? So if I divide one particular definition into various different parts, and if I understand it that ways, if I study it that ways, it becomes very easy. And this is literally the mantra of any competitive exam, particularly a law competitive exam. Divide the thing as much as you can. Go to the basics as much as you can. So coming back to this definition, I'm saying whoever. Does whoever mean an individual? Does whoever mean a human being? Does whoever mean a person? Does it mean a foreign national? Does it mean an animal as well? What do you mean by whoever? The answer to this particular question, whoever, you would find in the definition of persons in the Indian Penal Code. So you know who is a legal person to whom this particular definition. Right. So can a dog steal? Can an animal steal under this definition? Well, it depends how he or she is stealing, right? The next question, the next part is takes dishonestly. Again, if we go to the definition section of the Indian Penal Code, the term dishonestly has been defined. So we would know, again, and this is about, so we would know what it means to connect the dots across various sections of the BEHR Act. Whoever takes dishonestly, whoever takes any immovable property out of the possession of any person. So we were still on the idea of immovable property. Has immovable property been defined anywhere in the Indian Penal Code? Maybe not. But has immovable property been defined in any other law elsewhere? Yes, it has been. And that is where you learn to connect the dots across various provisions of different BEHR Acts as well. So when we are studying about the tricks to learn and understand the BEHR Act, one is that we are supposed to connect the dots within that particular BEHR Act itself. So for instance, the definition of dishonestly is found in the Indian Penal Code itself. The definition of whoever, that is a person, is found in the Indian Penal Code itself. But as someone has very rightly mentioned here itself, that the definition of the term immovable property is found in the Transfer of Property Act and the General Clauses Act, but not in the Indian Penal Code. And that is why it becomes important that you again pair up your BEHR Acts, you read certain subjects together, and you connect the dots not across or within your BEHR Act itself, but across various subjects as well, right? The next is out of the possession of any person. So what does it mean to bring something out of the possession of any person? Let's say there is a thing in my house which I've never touched for a very long time. I don't even remember whether it exists in my house or not. But one of my servants who's one day cleaning the house just picks up that particular thing and takes it, steals it. Has that person really committed theft? That person definitely has a dishonest intention. Yes. The person definitely took the thing. It was an immovable property. So the person definitely picked it up and took it away. But was that property in my possession? Is one of the questions that we understand through our legal lectures. But just taking an example here, definitely, even if I was not aware that that property is still in my house, it was still taken out of my control. So it was taken out of my possession, right? Oh, I'm sorry, I have to mention the term immovable property. It is movable property. Out of the possession of any person without that person's consent. So the person can even be a thief. Let's say someone has taken a property from my house, has kept it in his or her house, and someone else has stolen it from his or her house. Still, has the third person committed theft? Yes, theft has taken place. So friends, this is not a session on theft. We are not understanding theft here. But what we have to emphasize here is that please learn to divide the BEHR Act as much as possible, through sections of the 𝗲 Act as much as possible. One way is that you divide it into points. Second way is that you make flowcharts out of it. Third way is that you translate a particular section in your own language, the language in which you are most comfortable with. Because we see that the legal language in our 𝗲 Acts is slightly technical. So completely thinking that we are going to read this definition from the 𝗲 Act 10 times and we are going to be very comfortable and we are going to remember it inside out is not going to happen. So you have to make this language of the 𝗲 Act more flexible to your adaptability and to your understanding. So again, one way is to connect it into points, just like I did for theft. Whoever takes dishonestly any movable property out of the possession of any person without that person's consent is said to have committed theft. Second way is to sort of translate it in your own language. So let's say if you are in your own regional language, so let's say you're more comfortable with Hindi, तो आप इसको हिंदी में ट्रांसलेट करके समझो, या let's say you are more comfortable with कन्नड़ा और तमिल, तो इसको अपनी लैंग्वेज में ट्रांसलेट करके समझो ताकि ये आपके माइंड में एच हो जाए कि इस पर्टिकुलर प्रोविजन का मतलब क्या है. Now, understanding about, we have discussed three things here. We've discussed what is the ideal way to read the 𝗲 Act, what is the ideal way to sort of divide the sections and cover them. We have understood why it is important to always sort of complement one procedural law with two substantive laws, one a medium substantive law and one a very short substantive law. We've also understood that consistency is the key. The fourth thing that we really have to focus upon this thing with respect to our preparation is revision. So let's say you have covered 10 sections of a particular 𝗲 Act in a day. Next day, before starting the next 10 sections, please make sure that you are revising your previous notes on those particular sections of the 𝗲 Act, or you're revising your 𝗲 Act itself with respect to connecting the dots. Because if you don't remember your previous concepts, it makes absolutely no sense to move ahead. So please make sure that you are not only consistent with your preparation. Please make sure that you're not only just reading your 10 sections every day, you're also revising the previous sections. Why I'm emphasizing so much on this is because what matters a lot with respect to an examination, again, as we have talked about smart work, is that it is literally a scientifically proven fact that anything you read thrice would be etched in your memory. You would always remember it. So please make sure that you are at least going through a particular concept 3 times. If you're not covering a concept 3 times, please remember your preparation is not done. Having said that, 3 times is the minimum number of times you should revise a particular concept. What you have to focus upon is revision of the syllabus as many times as possible. And someone has asked a question here, minimum how many states should we consider for preparation? That literally and absolutely depends on your level of preparation. So if, let's say, as I've already mentioned, if you're starting with your preparation, please just shortlist one state and focus upon it. Know the syllabus of that particular state inside out. Make sure that you've made your notes on that. Make sure you are comfortable with the 𝗲 Acts of that particular state. Once you have done this, only then move to step 2. Only then you please move towards focusing upon other states, adjoining states, which have syllabus very similar to those states. So I'm familiar with a lot of aspirants who appear for the Punjab judiciary exam, but would also simultaneously appear for Delhi judiciary, for Haryana judiciary, for Rajasthan judiciary. Similarly, people or aspirants who appear for Delhi judiciary would simultaneously appear for UP, Bihar. They would appear for, again, Punjab, Haryana, and all these states. While it is a very good approach to take if you want to boost your confidence towards appearing for competitive exams. Like a lot of us have this mental block or a hitch towards sitting or appearing for a competitive exams. A lot of us would be very confident with our level of preparation, but the moment we'll sit in the exam hall, we'll see so many people are sitting with us. We start comparing our level of preparation with theirs is when we sort of lose our nerve. So there, if you're mentally prepared to fail and you feel that it's okay that I'll just take out my fear of sitting for a competitive exam, then it makes a lot of sense for you to please appear for as many number of competitive exams as you wish to, right? Or as many states as you wish to, and also a lot of other legal exams also, like the APO exam happens, UGC NET would happen. It makes a lot of sense for you to sit for multiple exams. Having said that, again, I would come back to my previous area of focus. Your first attempt should be your best attempt. So please, after making your best attempt, adopt these strategies, not before that, because a lot of times your failure tends to get on your head. You get into a cycle of it's okay for me to not clear the exam, and it sort of turns into an unending cycle. So it makes a lot of sense to know where you have to draw the line with respect to your preparation, and also to know when to stop with this particular exercise, and also when to start with the same, right? Okay, now coming back to the idea of revision, and finally, what should be the ideal timetable when you're preparing for this exam. When I'm saying that 4 to 5 hours are more than sufficient, this is how you can divide your time. First is that please make sure that you're sticking to 1 hour of newspaper every day. It is okay if general knowledge is not a very important component of your exam. Still, it makes a lot of sense to at least delve 1 hour of every day into the newspaper. Why? Because your newspaper covers your static GK, it covers your English, it covers your current affairs, it increases your analytical reasoning ability, it brings a lot of change, it helps you with your essay preparation. So these are the 5 things, or rather more than that, a newspaper would help you preparing. The Hindu is the most ideal newspaper to study for any competitive exam, let it be UPSC, Judiciary, or any exam which has general knowledge as a component. Having said that, the Hindu is slightly a tough newspaper to learn and understand to begin with. So if you're not very comfortable with the Hindu, the Indian Express, or even the Times of India in that line of priority is a good option to follow. But again, if you're preparing for the Delhi Judicial Services, particularly, reading the Hindu makes a lot of sense, because the level of the Delhi Judiciary exam is almost similar to the UPSC level. And as I've already told you, that your newspaper is not just going to help you with your with your general knowledge, it also covers a lot more other components. So please make sure that you're not just taking a shortcut, you're not just taking current affair notes of some coaching institution and feeling that you're going to be done with your preparation. Your newspaper plays a very important role in your preparation. So 1 hour of newspaper, 1 hour of learning the language. If you feel that you're very confident, please make sure with English or Hindi, please make sure that you at least know the technical terms, right? If you feel that this is one area which can still be given lesser time to, that's entirely a very subjective comment to make. So you can change it accordingly. But otherwise, if you're new to the preparation, 1 hour to learning the language is important. 1 hour to learn your procedural laws, again with 10 questions of the Bare Act every day, and finally 1 hour for the second substantive law. Having said that, your 4 to 5 hours would get covered, and this is ideal to begin your preparation with, right? So I will stop with my monologue here, and I would take a few more questions. Someone has a question. What is the bare minimum syllabus that's common in various state judiciary exams, or the part of the paper that is strictly contained with respect to certain subjects that can be focused during university? So friends, again, some procedural laws and some substantive laws are common to almost all judiciaries. Your civil procedure code comes in majority of the judiciaries. The same applies to criminal procedure code. Apart from that, it is a very good idea to be very well versed with Constitution of India, law of contracts, and the Indian Penal Code. If you're good with these five subjects, your journey through the judiciary exam is going to be very smooth. Can you please suggest books? Okay. I have suggested you the past year papers to begin with, and since this is a webinar on on starting your preparation, so please, to begin with, do not go towards books or do not go towards attaining a plethora of material. Please focus upon your past year papers and your Bare Acts. Once you are done with this, only then it makes sense to go towards books. Next is, how to check where we stand in our preparation and what's lacking, especially in case of mains, so far as self-study is concerned. Friends, what makes a lot more sense when you are doing self-preparation with respect to mains is to write one answer a day, particularly from the past year papers. Definitely, we at 𝗊𝗍𝗺𝗺 also have a Telegram group. We are soon coming with a WhatsApp group where you can post your answers. These answers would be peer reviewed and would also be reviewed by mentors. So you'll get a better idea of how you are writing a particular answer. In order to improve your writing skills, again, reading the newspaper definitely helps a lot. So that is one area where you can improve upon your writing skills. Apart from that, practicing one answer a day when you're preparing for mains makes a lot of difference, right? The next question is, kindly help to get the combination as what method should we follow for criminal law, or what is the best combination for criminal law for substantive and procedural. So just like we've given you a particular pattern on the civil laws, for procedural laws, it makes a lot more sense to start with the Criminal Procedure Code, combine it with the Indian Evidence Act and the Indian Penal Code. That is the best way to begin with, right? Any other questions? We are, I think, 3 minutes for the end of this session. I would love to take more questions. So please post your questions. Or anyone would like to speak, please raise your hand. What about the case names? See, so for most of the subjects or for most of the laws, there are certain landmark cases that you have to be well versed with. Having said that, there are certain judiciaries which have started questioning upon the latest case laws itself. So for instance, the Himachal judiciary has just passed, and if you will take a look at the question paper, you realize that a lot of recent case laws have also been tested upon. To begin with, it is an ideal strategy to have some basic landmark case laws in place. Like for instance, if we are studying the Constitution of India, there is Keshwanand Bharti, there is Golaknath, there is Inre Berubari, something which you will find in all the standard content that you're reading. These would be your landmark case laws. So for instance, if we are talking about the Indian Penal Code, the topic of murder would have very specific 4 to 5 landmark case laws. Kidnapping and abduction would have 2 to 3 landmark case laws. It makes a lot of sense to have in your notes itself to have highlighted these landmark case laws. When we talk about the latest case laws, which some of the judiciaries have started asking questions upon, your newspaper reading would do a lot of help in this, right? Will the All India Judiciary exams scrap the individual state exams? Yes, that is the most likely thing to happen. If the AIJS comes into account, then the state judiciaries would have relatively limited role to play. Ma'am, how to work on our language section? This is a very important question. So friends, if Hindi is one of the languages that you are preparing for, please, again, the 10 words or 10 sections is your mantra. So make sure that you're reading through a Hindi newspaper and identifying 10 technical words a day. That is more than sufficient for the time being. You don't have to go ahead with it while you're starting with your preparation. Slowly, as you keep getting comfortable with the Hindi language, after doing these 10 words a day, you can move to certain grammar books. But for now, this is what makes the most sense. How do we...
Good evening, madam.
Yes.
Can you suggest some books for books to study, madam?
Okay, since this is the introductory session, I would like to mention here again that we are beginning, a lot of us are beginning our preparation, and to begin with, please focus only upon the past year papers and the bare acts. Only then we'll get on to the books. So maybe in the next session, we'll take up that particular topic of what books should be read. But for now, please take only the past year papers and the bare act, right? Okay, I think we're running short of time. There are a lot of questions coming in, so maybe we'll take up a session on this again, or we'll continue with the session. I hope you've enjoyed today's session, and you could always mail your queries to shweta.d@𝗀𝗍𝗺.in, I repeat, you could mail all your queries to me at shweta.d@𝗀𝗃𝗍𝗺.in. Someone has asked a question, how is 𝗀𝗃𝗍 contributing towards this? Friends, we have launched a judiciary course where we are sort of consolidating all this material and giving regular guidance on the same. Again, if you're interested in this, you could get in touch with any of our 𝗀𝗃𝗍's faculty and people who are working with 𝗀𝗃𝗍, and you can always mail me at shweta.d@𝗀𝗃𝗍𝗺.in. Right? Okay, I think we are running short of time, so we'll have to end today's lesson. I hope you've enjoyed today's lesson and it was helpful to you. I'll be waiting for your queries, and if there's a need, we'll have another lesson on this particular topic again. Yeah. Okay. Thank you guys. Bye.